Hello, everyone. This is Professor James Smith, and I'm here again to talk to you about evidence. Today's topic, hearsay. Now, hearsay is a subject that befuddles a lot of attorneys and judges. I know lawyers who've been practicing for quite some time, and they still say that they really can't grasp hearsay. I think in large part that's because of the way in which hearsay is taught in a lot of our law schools. What I'm hopefully going to be able to do today is provide you with a framework for understanding hearsay, which is based on some instruction that I got when I was a judge advocate in the United States Army. The key to understanding hearsay, the key to understanding obviously any rule of evidence, first starts off with reading the rule. Now, one of the more exciting things that's taken place recently is if you look at the Federal Rules of Evidence, there's been an effort to simplify the language of the rule to make it easier to understand. Now, the rule I'm talking about specifically is Federal Rule of Evidence 801. And what I'm going to do now is actually read from the rule. Federal Rule of Evidence 801 says, quote, hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, and a party offers in evidence to prove the truth of the matter asserted in the statement. Now, that last portion is actually quite a significant change from the way that the rule was written before. Before, the rule simply said that hearsay was an out-of-court statement being offered to prove the truth of the matter asserted. Now, that final portion, the truth of the matter asserted, caused a lot of confusion for students. Students frequently would confuse that topic, and thus they had a hard time understanding the rule. But the way that this new rule is written, it makes one thing clear. When we talk about the truth of the matter asserted, we're talking about the truth of the matter asserted in that statement. Now let's go back and break down hearsay. Why do we have the rule? Well, the reason we have the rule is very fundamental. We want juries to hear only reliable evidence. And hearsay, in its purest form, can be highly unreliable. Individuals have a right to confront their accusers, and we want fact finders to know exactly the context and circumstances under which statements were made. The problem with hearsay, the problem with allowing individuals to come in and testify about what they heard someone else say, or to even testify about their prior statements, is that we don't satisfy those confrontation rights, and we don't address those concerns that people have about the context in which a statement is made. So, let's break down hearsay. First and foremost, the first step in the analysis is to make certain that we have a statement. And what is a statement? A statement is an assertion. It's either oral or written or even nonverbal conduct that's intended by the person who engages in those actions as an assertion. So, for example, the light was red. The car went through the stop sign. Those are clearly assertions. And notice, again, as I said before, statements can be oral, they can be written, or it can be nonverbal conduct as long as it's intended to be an assertion. So that's the first step, make certain that you have a statement. The second step then when analyzing hearsay is to determine who's the declarant. Key thing to understand is that the person who made the statement, right, the declarant, and the witness who testifies about it can be the same person. The third step in the analysis when deciding whether or not something is hearsay is to determine whether or not the statement is being offered for the truth of the matter asserted. Now, I have a way that I believe helps me and will help you in understanding hearsay, and that is to break that down even further and simply to say that hearsay is an out-of-court statement offered for its truth. Again, hearsay is an out-of-court statement offered for its truth. When deciding whether or not something is hearsay, you should first consider whether the statement could be offered for some purpose other than its truth. Let's take the following example. Let's say that Jack is being charged with murder, and Jack's defense is self-defense. Here's the factual scenario. Jack is sitting in a bar. John comes in and starts to walk to him. Jack suddenly reaches into his pocket, takes out a gun, and shoots John dead. Jack claims self-defense, and as part of his self-defense claim, he wants to be able to call as a witness his friend Paul, and he wants Paul to testify. He wants Paul to be able to come in and present testimony that Mickey had told him, and it told Jack, that John was looking for him and wanted to hurt him, in fact kill him, because he suspected he was having an affair with his girlfriend. So let's break this down. First off, the defendant is Jack. He's accused of killing John. He wants to call Paul as his witness to testify about a statement made by another party, an out-of-court statement, that John was on his way to the bar, that he was looking for Jack, and that he wanted to hurt him, in fact kill him, because he suspected he was being involved with or was in an affair with his girlfriend. So first, do we have a statement? Clearly, yes, if you use the definition I gave you before. Is it an out-of-court statement? Yes, it was a statement made out of court. Is it being offered for the truth of the matter asserted? Well, the argument that you could make that it's not hearsay is that that statement was not being offered for its truth. Why? Because the statement is being offered as evidence of state of mind, as evidence of the effect that it had on the listener. Jack's defense is self-defense. One of the elements of self-defense is showing reasonable apprehension of great bodily harm. Having heard the statement made by the party outside of court that John was on his way to hurt him and kill him because he suspected of being in an affair, the fact finder doesn't have to determine whether or not that statement is true. The fact finder doesn't have to decide whether or not the statement is credible. Rather, the evidence, the statement, has some relevance for a purpose other than for its truth. The relevance is because it goes to the defendant's state of mind and it helps prove his self-defense claim. So that's an example of how a statement could be offered for some purpose other than its truth. So, just to sum up the little nugget of hearsay that we've talked about tonight, read the rule. FRE 801 has been modified in a substantial way to make it easier to understand and easier to apply. With hearsay, we're talking about an out-of-court statement being offered for its truth. The first step in the analysis, do we have a statement? We know that a statement is something that's intended as an assertion. It can be oral, it can be written, or it can be nonverbal conduct. It obviously has to be by a human being, by a person. Make sure that we do the analysis to determine who's the declarant and who's the witness, and understand that the declarant and the witness can be the same person, and then decide whether or not the statement is being offered for its truth. When deciding whether or not something is being offered for its truth, consider if there are some other non-truth purposes for which the evidence can be offered. If that's the case, then it's not going to be hearsay. We're really going to take a lot of time and break this rule down, but that's just a good introduction. In our next topic, we'll explore some other non-truth purposes for offering out-of-court statements. Once again, this is Professor James Smith on evidence. I look forward to any questions or comments you have. Rate, comment, and subscribe. And evidence is fun. Take care.